correct, whether we, agree with it 100% or whether we think it would do the job. It is now 7, it's the new amendment, and I did change this one this evening. This one was out earlier. It is now a preliminary plan. And I'd like to read it. On page 80, after line 19, you would add the following. However, any project for which a preliminary plan was submitted prior to September 27, 1988, the entire project shall be exempt from the provisions of this bill and shall be submitted to develop under regulations in effect at the time of initial submission, provided that the preliminary plan and final plan have or do not expire as stated in sections 16120 and 16121 of the Howard County Code. On this one, I introduced it, and it's a preliminary plan. It's not the sketch plan. Incidentally, we got a lot of figures from the Planning and Zoning Office this afternoon. I questioned those figures, but at this time I have no way of knowing. They looked a little bit large to me, and the 6,500 lots did seem like a great deal. But in the preliminary plan, you only have a little better than 600 lots. That's not much for Howard County. I think here, somewhere you draw the line, and it's not a stale saying or an old saying. It means a lot when you say don't change the rules in the middle of a card game. We did change the rules here. Everyone worked under what they believed was correct. They bought, they purchased, they came in and showed their plans. They did what they thought was proper and right, and it was legal in every way. I think to cut them out and not grandfather anyone in would be certainly, and we're not grandfathering everyone in here. A lot of people made a sketch plan. We're cutting out probably, according to the figures here, it would be 6,000 because we have 60 homes. So we're coming in under a very small and easy thing to amend here, or not to amend, but an amendment. I strongly support grandfathering. I think it's fair, it's right, it's just. If I were in a lawyer sitting in a court of law, I would have no other way that I could vote other than to say that you have to grandfather these people in. In fact, I believe that there is a law case here. Thank you.
Ms. Beltram?
Yes. There is a grandfather clause already in the subdivision regulations providing that those parcels that have preliminary development approval will come under the current law. I've talked to realtors and developers privately, and they've told me that the contracts that developers sign when they purchase land has contingency clauses in it protecting them when government changes its rules in the middle of the game, and that if the rules change, they can get out of that contract, or they can renegotiate the price to the landowner. And that what they usually guarantee in the contracts is where they are at record plat. So the developers are not going to lose money if this passes. Now they may have spent some engineering money, but to make millions of dollars and to lose 50,000. But the contingency contract is there, just for purposes like this, because government does change the rules in the middle of the game.
Ms. Beltram,
Yes.
excuse me. I exercised my position as chair to ask for respect for Mr. Figge's opinion. I will now ask for respect to hear Ms. Beltram's opinion.
So we're talking about 6,000 acres versus approximately 600, and I do believe the Office of Planning and Zoning. And so the grandfather clause is in there. It's a middle of the road clause. It could have been stricter. Maybe it should have been stricter. So there's already a grandfather clause in the law.
Is there any further discussion?
Yes.
Mr. Figge?
Preliminary can be handied back, over and over again. If it's not approved, the county could drag its feet on all these and just kill them. So I don't agree with that. That's why I have the submittal of the preliminary plan, and that's why the amendment is the way it was, to protect someone in case the office would want to drag its feet or want to send those back, and that's the difference.
Is there any further discussion? Mr. Vogel?
Ms. Pendergrass.
Okay, I have something to say as I vote. In the code, it already has a provision for grandfathering, as Ms. Beltram said. And what the provision is not for this bill or any one single bill. It's a specific provision for grandfathering for any change in these regulations. And the grandfathering that is there, that exists now for any changes, says when the law is enacted, which is 60 days after we vote on it, and at the time, the place it would have to be in the process is it would have to have preliminary approval. That's the way the law is written now. So we're changing some rules, but we're not changing all the rules because that rule is already there. It does allow for grandfathering midway through a process. I think that because the rule is there and these things have been already thought of by previous councils, I will vote no.
Hold those signs up. So she can see.
Ms. Beltram.
No.
Mr. Figgy.
If I felt as comfortable as my two colleagues that it's already there, I would vote yes, and I am voting yes.
Mr. Gray.
Well, the grandfather is there in terms of the 60-day period, which is February 3rd, and I don't know how OPZ will operate on these that they now have in hand, and I vote no.
Ms. Keeton.
I had a long discussion with the head of planning and zoning earlier this morning. Charlie, I'm sorry, but I'm voting no.
Okay. I move Amendment 8. This has been submitted by Dr. Gray. Would you be so kind as to second and explain?
So on page 16, line 11, line 11, and what it does, the bill, is delete neighborhood and substitute subdivision. And if you look at the previous page 15, line 27 or 28, and at the top of page 16, it has the locality within the neighborhood. So obviously the old reference was to an area which was smaller than a neighborhood, which I think was a subdivision. And so that's what I'm putting here.
Where did you just read that? Just
At
point.
the top, it says locality within the neighborhood.
Thank you. Is there any further discussion of council members?
No.
Could I, at this point, ask someone from planning and zoning or the administration to comment, because this is new and I have not talked to anybody about this. Oh,
Can I comment?
excuse me, Mr. Figgy.
I'd like to comment on that. We've done that before when we were up here for a hearing, and I respect you, Mr. Pendergrass, but I think that we gave them an hour at the beginning of the testimony before, and oftentimes we come in to do this. If you're going to do that, then I would request that we hear from more than one person. I think that if you did, and you said you read this and you had plenty of time to read it and understand it, I think that it's something that you met with the Office of Law numerous times, and I think you've had plenty of opportunity to get any information that you need, just like the rest of us.
Dr. Gray?
Let me read how it would read. It said, reserved a separate lot. We're talking about, I guess, open space here, open space. He said it's a separate lot reserved for the common use of the residents of the neighborhood. Now, some of you who've been involved in zoning cases know that a neighborhood may include 3 or 4 or 5 subdivisions. And all this is suggesting that each separate subdivision should have its own open space.
Yeah. Well, that sounds.
Yeah. That's all it suggests. As opposed to
I
one
don't-
preparing a open space
I'm
for
going to.
the entire neighborhood, when in fact the neighborhood is a large area.
Okay, I'm sorry, Mr. Figgy. I got this amendment when I got in at 6:30 or 7 o'clock tonight. I would like to hear a response because I would like to be able to consider voting for it.
I miss Pendergrass. I think
Yes,
this
Dr.
amendment
Gray?
was available earlier today. This is one of my amendments available earlier today. But I don't want you to give the impression that I just.
It may have been. I didn't see it. I did not see it. And these amendments have been, in general, difficult to figure out which one came in when. Is there somebody from the administration that would like to comment on this, please? Do you see any impact of this that I'm not seeing beyond what we've heard?
Well, at the risk of commenting on policy rather than legality, obviously the change is designed to restrict the dedication of that open space area for the subdivision as opposed to the general neighborhood. I would imagine that in the practical world, you may have several different subdivisions which may end up having open space contiguous to each other, and of course the bylaws of any homeowners association, they can control who can use the facilities under what circumstances. So I don't think there's any problem with the amendment. I don't think it's going to have any horrible effect that I can see.
Okay, I have a concern that if you have open space, and maybe Mr. Avon can answer this, if you have open space and you have 3 subdivisions and they're adjacent and you have this one big open space, first of all, I think that we're talking about something that's dedicated to the county. And if it's no, we're not. That's my problem. If we're putting it together and trying, for instance, to be able to put a park on it for a broader group, if that's not the intent of this, then I have no problem with it. Could you clarify, Mr. Avon?
Yeah. This does refer to space reserved for the common use of the residents, not for public use.
Okay.
The only question that arises here that may be confusing is how it would apply in Colombia, where basically neighborhoods are defined fairly specifically and subdivisions aren't clear. So what open space would relate to in Colombia because of this may be thrown into some confusion, because subdivisions aren't as clearly defined as outside of Colombia, where neighborhoods in Colombia are fairly clearly defined, and open space, in fact, is defined in relation to those neighborhoods. I think we could certainly work with it. It just raises that issue of interpretation in my mind at this point.
Okay. Ms. Beltram first, because
Yes, well,
she
the
had her hand up
converse
first.
is true. How do you deal with it if it says neighborhood in non-Columbia? So you might have to put both. I don't know. Yarn, do you understand?
I was
How do you
thinking,
do-
I was
how do you
thinking
do that?
primarily of non-Columbia. How have you dealt with it in existing legislation? Because the existing legislation says locality within the neighborhood. How have you dealt with it?
Yeah.
It's frankly not been an issue.
So I don't expect it to be an issue, right?
Okay,
we'll have no-
that's what I wanted to understand. In either case, we may have a problem with it. It's a very small.
What it does pick up and relate to is the fact that neighborhoods are defined in the general plan. So it does have some relationship to other documents that we do use.
Can we put both?
One could put both in, give the choice.
Is there a way to word it that you could put both?
Vernon, would
Bernie?
you accept
Well,
both?
we could put both. That's fine. That helps. We'll
Would it
say,
be neighborhood or subdivision, or?
yeah, that's fine.
Okay.
We could just, other words, why don't we say on page 11, line 11,
16? I'm on 16.
what did I say?
You said 11,
Page
I'm on
16.
16.
Line 11,
Oh, that's what it is. Yeah.
after the word, I'll do it the easy way. On page 16, line 11, before the word neighborhood, add
Subdivision.
subdivision or.
Great. So that's a substitute amendment that's been moved and seconded. Any further discussion? Mr. Vogel, would you call the roll, please?
Ms. Pendergrass,
Yes.
Ms. Beltram,
Yes.
Mr. Figgy,
Yes.
Mr. Gray,
Yes.
Ms. Keeton.
I move Amendment 9. Dr. Gray, would
Second.
you?
Second. I think this one might have been dealt with. It's on page 19, line 11, after the word use, add in accordance with the general plan. I think, was that dealt with?
Yeah, for clarification, that was dealt with in the administration's amendment number 1, where they included the general plan.
Okay.
At that point.
So, do we withdraw Amendment 9? How do we do that now that it's been moved and seconded? Or do we vote against it?
Vernon can,
Well, I just won't even offer it.
All right,
And I won't offer number 10 either.
all right. I move Amendment 11. Dr. Gray?
Second. I've been one who've always been supportive of trails. And what this amendment does is to add trails in a number of places after pathways or walkways, and also provides a definition for trails and make certain exemptions for trails as exemptions are made for pathways and walkways. And so maybe I should read it. On page 8, line 12, after pathways, add trails. On page 16, line 7, after stations, add as shown in the general plan and hiking, biking, and equestrian trails. On page 18, line 5, before the word walkways, add trails. On page 18, line 22, before the semicolon, add trails. On page 28, line 14, add the following trails. Definition, as distinguished from a walkway or pathway which are paved natural path within a minimum 10-foot hiking, biking, equestrian right-of-way intended to be open for common use. On page 48, line 20, after comma, add trails. On page 49, line 18, after the word crossing, add trails. On page 58, line 16, before the word or, insert trail. Page 70, line 18, after the word paving, add a semicolon and the word trails. On page 71, line 26, after the word roads, add a comma and the word trails. And basically it adds trails to the whole aspect.
Yeah, I have a question about this. I have not worked through all the places where you've made changes. I'm concerned how many of them are affected by the fact that there is no longer a 5% open space requirement in the R district. Has anybody gone through and seen the impact of that?
No, I've talked with, in fact, Mr. David may want to even comment on this, because my position is that easements can be used as we do with some other things. And I think the owner of the property where there's an easement is absolved of any liability for anything that might occur on that particular, be it a pathway or walkway or trail. So I think that, we have pathways included, which are paved areas, or walkways are paved areas. And so it's at a non-paved area.
Okay. Mr. Avon, would you be kind enough to comment?
There is nothing in the regulations that give us the authority to require easements in the western part of the county. So by eliminating the 5%, we do not remain with any authority to require those easements. They would have to be completely voluntary to allow for these trails in the western part of the county.
So that could be corrected at a later time, right?
Or now, if you're in the majority. Vernon?
Did you hear what she said?
No, well, it has to be worked through later. I think we
What she said was it could be corrected
needed-
now if you were in the majority.
It needed to be I think we need to add trail at this point, and I think we can correct whatever deficiencies in terms of easements and things like that at a later point, because I think that the whole idea of trails and the interest in trails seem to get a back seat, let's say, to a lot of other things. And I thought there was good testimony on that. And even 3 or 4 years ago, we had good testimony on trails as well. And we were showing good slides on how trails exist in, I think, some of the western parts of the country, even in urban areas, how they provide trails under overpass on highways and other things like that.
Okay. Is there any further discussion? Would you call the roll?
Ms. Pendergrass?
Because of the deletion of the 5% open space requirement in the R district, I am not willing to deal with the concept of trails at this time. At some point in future, if we deal with giving the county the authority to acquire the land to put the trails on, I might consider seriously supporting this amendment. I have to vote no.
Ms. Beltram?
Well, I'm going to vote yes with the hope that we work something out, because I've heard from those people too. I think the voluntary effort will not be successful, and I think we'll have to amend this to provide a method of having access to the open areas for the trails to be used for. So, but I will vote yes now.
Mr. Figge.
I think there's a safeguard here that we will certainly be able to look at the way that we're going to acquire those trails. When I spoke a few minutes ago on the 5%, I have no problems with county purchasing that or that type of thing. I have nothing against trails. I just don't think the county should be allowed to take it. So my vote is yes.
Mr. Gray.
Yes.
Ms. Keeton.
Yes.
You also have number 12. I have that in here.
Okay.
All right, so I'll, 20, okay. You explain that.
Okay. I move approval of amendment number 12. Dr. Gray.
Second.
And you need to explain it because it's
Second,
changed.
what this does on page 48, let me put it this way. In terms of removal or grading or removal of vegetation cover near permitted on land with existing slopes of 25% or greater, there are two exceptions which are provided here in the legislation. And so what this amendment speaks to is the second exception. And the amendment is being offered because it does provide for the review process by the Soil Conservation Service. And so the amendment is on page 48, line 23, delete 10, after the word then, delete 10,000, add 20,000. And that does provide for the soil conservation review process.
Okay. Is there any discussion? Okay. I would like to ask Mr. Avon to comment on why he picked 10,000 so that I could understand the difference in impact between 10,000 and 20,000. Could you do that? Where you usually, when you come up with a number, it's not just accidental.
My understanding is this is proposed to be changed to 20 now. Yes.
Yeah.
10,000 was basically the equivalent of one lot in the R12, which we felt was a reasonable kind of standard for an exemption. That was the basis for 10,000. It was a fairly small area that would allow one lot in the R12.
So this would basically allow 2 lots.
Approximately 2 lots, yeah.
Okay. Mr. Vogel, will you call the roll?
Ms. Pendergrass.
No.
Ms. Beltram.
No.
Mr. Figge.
Yes.
Mr. Gray.
What this would do, as I pointed out, provide for the soil conservation review process. They cannot review otherwise. So I'm saying yes.
Ms. Keeton.
When you read on page 48 here, existing slopes of 25% or greater, grading or removal of vegetated cover shall not be permitted on land with existing slopes of 25% or greater, except when the Office of Planning and Zoning determines it's necessary for the extension of roads, pathways, or utilities, or when the contiguous area of slopes of 25% or greater is less than 10,000 square feet and is not adjacent to a floodplain or wetland. Areas containing existing slopes of 25% or greater should be included in open space lots, but may instead be included in wet, and goes on. So I'm voting yes.
Okay. Mr. Vogel, will you call the roll on the bill as amended, please?
Ms. Pendergrass.
Yes. Oh, yes. I thought you were going to ask me a question.
Ms. Beltram.
Yes.
Mr. Figge.
Yes.
Mr. Gray.
Yes.
Ms. Keeton.
Yes.
Those were very short statements. Would you continue with final consideration, please, Mr. Vogel?
Bill number 67, introduced by the chairperson at the request of the county executive, an act amending section 2.207, notice to the public, and section 16.303, conduct of hearings of the Howard County Code regarding...
Mr. Vogel, would you like to take a minute while the roar dies down? Because 66 was the bill that they were concerned about. We passed it with amendments.
I'm real surprised. I thought we'd see this place really packed tonight. There's still a few dozen, there's still a few dozen seats. The way from what we heard then, I thought they were going to be standing up in here.
It's rare that they say
A lot of people think it's obvious that people would vote for the
Trinity is. I was just here to hold the beer.
and they don't have to worry about
Mary
it.
Lynch predicting that it was going to be the biggest thing we've ever had
Oh, no, I wouldn't say that.
because of the number of names.
A couple more bills from a couple months from now might be.
Oh, God, don't say that. And that's what scares me on this.
Get more seats.
Yeah,
I don't think they do. I think that's the problem. And I've nothing against your pass,
Lloyd,
by the way. I just feel that
take
since
your
we
little sign
amended
with
that
you.
it's not appropriate. But it's passed.
yeah, we can go now. We can go
Okay,
now.
okay.
No.
Excuse me. Where's Miss Keeton? Okay, Mr. Vogel, you may proceed.
Bill number 67, introduced by the chairperson at the request of the county executive, an act amending section 2.207, notice to the public, in section 16.303, conduct of hearings of the Howard County Code regarding notice provisions for petitions to clarify or revoke a special exception, and notice provisions for hearings to clarify or revoke a special exception.
Okay, this,
Just let him
Um,
go.
I move approval of Council Bill 67.
Second it.
Okay, this bill requires more notice